Justice Alito?
Mr. Letter, I was somewhat baffled by your answer to Justice Ginsburg about the use of congressional subpoenas for purposes of harassing a president. Your final answer was the courts can take care of that, but that's the issue here, whether something should be done to prevent the use of these subpoenas for the harassment of a president. So could you explain what you meant?
Absolutely, Justice Alito. This court in Clinton versus Jones and in other cases like Nixon versus GSA has said we are here to protect the president if there is harassment from Congress or private individuals. And here, there clearly, though, is, we think, valid legislative purposes. The four courts below all found that there was.
I don't want to cut you off, but I have very limited time. So your answer is that the protection against the use of a subpoena for harassment is simply the assessment whether the subpoena is relevant to some conceivable legislative purpose.
Correct. That's what the court has said, but also, again, Clinton versus Jones and Nixon versus GSA.
And that's not much protection. In fact, that's no protection, isn't it?
It is protection, Your Honor, if what Congress is doing is interfering with the president's ability to do his job. These subpoenas are to private parties. The president does not need to do anything. When you talk
about interfering with the president's ability to do his job, do you mean this is going to take up too much of his time? Or does that include the potential for the use of subpoenas solely for harassment and political purposes?
Your Honor, if they were solely for harassment, then they wouldn't meet the standards of they have to be pertinent to a legislative purpose. So I think the combination of all of those provides ample protection, but there's no...
But you were not able to give the Chief Justice even one example